This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about marine insurance and why requiring an insurer to waive its right of subrogation is a valid and enforceable contract, and why waiver of subrogation will always apply whenever the parties agree to it, whether in a marine or a fire and casualty policy. Competing motions for summary judgment were presented to the United States District Court for the Eastern District of Louisiana about whether a limitation-of-liability action arising from the listing and capsizing of the liftboat RAM XVIII, the motions present the principal question whether Fieldwood, the charterer of the liftboat, must defend and indemnify Aries, the owner of the liftboat, and U.S. Specialty, Aries Insurer, under a master time charter agreement from the personal injury claims brought by employees of Fluid Crane and Construction, Inc. and United Fire and Safety, LLC, the subcontractors who were aboard the RAM XVIII when it capsized. Fieldwood moved for partial summary judgment enforcing waivers of subrogation in the master time charter agreement and the relevant U.S. Specialty insurance policy. The case entitled In the Matter of Aries Marine Corporation et al., the United States District Court for the Eastern District of Louisiana on November 20, 2024, resolved the disputes. The USDC resolved what was a 5-year-old limitation of liability action that arose from the listing and capsizing of the liftboat RAM XVIII in the Gulf of Mexico. Aries chartered the RAM XVIII to Fieldwood under a master time charter agreement and in relation to work being performed on one of Fieldwood's offshore platforms. Under those master service contracts, Fluid Crane and United Fire sent employees to work on Fieldwood's platform. Those employees were aboard the RAM XVIII when it capsized. U.S. Specialty, for its part, underwrote an insurance policy that provided Aries with certain coverages in effect when the RAM XVIII capsized. 6 employees of Fluid Crane and 1 employee of United Fire, all of whom were aboard the RAM XVIII when it capsized, brought personal injury claims against Aries. The motions before the court present the principal question whether Fieldwood must defend and indemnify Aries and U.S. Specialty from those personal injury claims. The time charter Section 10 features a waiver of subrogation provision mandating that underwriters of all policies of insurance required by Section 10 of the Charter shall waive their rights of subrogation against the charterer group, which included Fieldwood. The policy provides coverage to Aries for protection and indemnity, including coverage for personal injury liability. The policy included a waiver of subrogation provision that applies to the protection and indemnity coverage. A separate section of the policy governing hull insurance coverage also contains a waiver of subrogation provision and a provision naming Fieldwood as an additional insured. Fieldwood executed the master service contracts with Fluid Crane and United Fire, respectively. Fluid Crane and United Fire agreed to indemnify the other entities involved from claims asserted by their own employees, as well as to be responsible for defense costs for such claims. Fieldwood moved the court to grant partial summary judgment enforcing waivers of subrogation in the time charter and policy and dismissing Aries' cross-claim and U.S. Specialty's complaint and intervention. The court held that Fieldwood is entitled to partial summary judgment because a review of the time charter and the policy confirmed that both Aries and U.S. Specialty had waived their rights of subrogation against Fieldwood. The policy unambiguously states a waiver that U.S. Specialty's right of subrogation will not exist in favor of Fieldwood. The policy features a waiver of subrogation provision, and that time charter qualifies as the written contract that requires U.S. Specialty to waive its right of subrogation against Fieldwood because the time charter features a waiver of subrogation provision mandating that the underwriters of all policies of insurance required by the contract shall waive their rights of subrogation against the charterer group, which, of course, is still included Fieldwood. Because a review of the time charter and the policy confirmed that U.S. Specialty unambiguously waived its rights of subrogation against Fieldwood, and because the claims asserted in U.S. Specialty's complaint and intervention rest on a subrogation theory, the court granted Fieldwood's motion for summary judgment and dismissed with prejudice U.S. Specialty's complaint and intervention. The USDC concluded that the waivers of subrogation in Fieldwood's favor are enforceable, and Aries and U.S. Specialty have not adequately presented any argument that would allow the court to hold that their claims for defense and indemnity can survive despite the enforceability of the waivers of subrogation, and therefore Fieldwood's motion for partial summary judgment was granted. In my opinion, insurance policies, like the marine policy interpreted in this case, contain standard language authorizing the insured to waive the insurer's right of subrogation if it does so before there is a loss. Since the litigants sought subrogation recovery, which had been waived by the standard language of the policy, this 5-year-long litigation was resolved by the acceptance of the court of the waiver of subrogation. It teaches us that insurance companies might want to reconsider the automatic waivers of subrogation in their contracts, and their lawyers should know that they exist and not bring actions that were waived. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you can also see these videos and subscribe to them. They're also free on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos, and let them also subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.